thank you for joining us for today's webinar. My name is Kelly Jenkins-Pultz, and I'm the Acting Regional Administrator for the U.S. Department of Labor Women's Bureau. It's my great pleasure to welcome you to our program. The Women's Bureau receives many calls from women and men who need more information about their rights to leave during pregnancy or following the birth or adoption of a child. Because there are several federal and state laws that offer a variety of protections, and it's understandable that many questions about eligibility and coverage exist. Our goal today is to introduce you to these programs and to provide resources that will help you plan for this significant life event, or if you're an employer, to inform you about the programs and give you resources to administer them successfully in your workplace. We have a very distinguished set of panelists today. I'm going to introduce you to them all now, and as you're listening to their presentations, feel free to use the Q&A box at the bottom right of your screen to type in a question you may have. We will respond to all questions at the end of the presentation. We'll also provide you with a resource and contact list so you can follow up with any of our speakers following today's conference. In addition, this event will be recorded and posted online afterward. Our first speaker will be Sharon Turman. She's a senior staff attorney with the Legal Aid Society Employment Law Center. Sharon will provide an overview of federal and state laws on pregnancy discrimination, reasonable accommodation for pregnancy and disability leave. Next, Julia Parish, a project attorney who's also with the Legal Aid Society Employment Law Center, will discuss the Family and Medical Leave Act and the California Family Rights Act. Jenya Cassidy is project director of the Work and Family Coalition at Next Generation, and she'll share information about California paid leave following the birth or adoption of a child. Following Jenya, Genevieve Colvin, program manager for BreastfeedLA, will discuss lactation accommodation in the workplace and educational environments. I'll return after Genevieve to share information about negotiating workplace flexibility, and then we'll be ready for Anna Fortes, program analyst in the Women's Bureau, to moderate our question and answer session. Started with our first speaker, Sharon Turman.
Thank you. I'm Turman. I'm a senior staff attorney at Legal Aid Society Employment Law Center. I want to welcome everyone and thank you for joining. At Legal Aid Society Employment Law Center, we have a work and family helpline, and we receive calls from workers every day who have questions about their rights under pregnancy leave laws, bonding leave laws, paid family leave. So if people have follow-up questions after the webinar, you're welcome to call our work and family helpline or to get in touch with myself or with Julia Parish, who will be the next panelist. So about today, I'm going to give a brief overview of accommodation laws. I'll speak briefly about pregnancy accommodation laws. Then I'll talk about pregnancy disability leave in California. I'll talk about the state disability insurance program, and we'll discuss who is eligible under each of these laws. First, pregnancy discrimination. It should go without saying that it is unlawful under both California and federal law to discriminate against someone because they are pregnant, because of childbirth, or because of a related medical condition. And that's true under the California Fair Employment and Housing Act, also under the Federal Pregnancy Discrimination Act. From that point on, though, the two laws really diverge, and California law is much more protective of pregnant women in the workplace. Then is that California law covers just more people. California Fair Employment and Housing Act applies to all workers who work for employers with 5 or more employees. The Pregnancy Discrimination Act only applies to workers who work for employers with 15 or more workers. But beyond that, the two laws are significantly different because the California law actually provides workers with affirmative entitlements to things like pregnancy accommodations and pregnancy leave. And the federal law simply says that pregnant women should be treated the same as other people at work who are similar in their ability or inability to work. So if an employer has no policy or practice of accommodating other workers who are not pregnant, then under the Pregnancy Discrimination Act, they arguably do not have to provide those kinds of accommodations to pregnant women. California law is really expansive and important and is actually quite unique in providing these affirmative protections. But just to say, under both California and federal law, it's unlawful to fire someone because they're pregnant. It's unlawful to force them on leave because they're pregnant, to demote them because they're pregnant, really treat them worse in any way because of their pregnancy. So briefly about California's Pregnancy Accommodations Law, what this law says is that pregnant women or any woman who is affected by childbirth or a related condition is entitled to a reasonable accommodation at work. And that can be things. It could mean having a stool to sit on while at work. It could mean having help with heavy lifting. It could also mean changing your job in certain ways by relieving you of certain things that might cause danger to your pregnancy, like exposure to toxic fumes or climbing a ladder, for example. The accommodation has to be granted if it's reasonable and if it's on the advice of your healthcare provider. The other piece of the accommodations law in California is that you are entitled to transfer to a less strenuous or less hazardous position if your healthcare provider advises that and if that can be reasonably accommodated. California pregnancy accommodations, like I said, is quite unique. There are only a handful of laws around the country that have these affirmative accommodations protections. They're really important because they allow pregnant women to keep working and supporting their families while maintaining healthy pregnancies. There is a bill pending right now in Congress called the Pregnant Workers Fairness Act that would extend those protections around the country. Next, I want to talk about pregnancy disability leave law in California. This law is also unique. In California, we have a law that's been on the books since the late 70s that says that pregnant women are entitled to up to 4 months of job-protected time off while they are disabled by pregnancy, childbirth, or a related condition. So most women will not need 4 months. Actually, for a typical pregnancy and childbirth without complications, a woman will be certified as disabled beginning 4 weeks before her due date through 6 to 8 weeks post-birth. It would be 8 weeks in the case of a C-section. This is different, and it's up to the healthcare provider to certify what the individual woman needs. Some women may go on leave early. Some women may need to stay on leave later. That law allows employers to demand a medical certification to document the employee's need for leave. It all is up to the healthcare provider. The law, as of 2012, requires employers to continue health insurance benefits to women who are on pregnancy disability leave. And that's really important because women who are about to have a baby need to keep their health insurance and have good medical care. So that was an amendment to the law that we were really pleased about. The law also prohibits employers from forcing a woman to take pregnancy disability leave. It's really up to the woman and her health care provider to decide when she needs to go on leave. Job protection aspect of this law is really critical. What it says is that in terms of job protection, that's what is so important about this law. It does not actually provide you with any pay. It just says that you can take the leave and come back to your job. And the job protection piece of this law applies to all workers who work for employers with 5 employees or more. You do not have to have served any particular amount of time in order to be entitled to this leave, nor do you have to be a full-time employee. So it's a really broad protection. And even if you need more than 4 months, there may be protections available. So Some women, for example, might have preterm contractions. They may need to go on bed rest very early on in the pregnancy, or they may have complications post-birth, and they may, for example, have postpartum depression, and their doctor may recommend that they stay. In that situation, the woman can request additional leave as a reasonable accommodation of her disability, and that would fall within the Fair Employment and Housing Act's general disability provisions. However, the employer would be able to deny the extension of leave if it could show that it would cause an undue hardship to the business. So we've been talking about job protection. Now I want to turn to wage replacement while you're on pregnancy disability leave, because as I said, the PDL, the Pregnancy Disability Leave Law, does not actually provide for pay. It just gives you the time off and gives you the right to come back to work. But in California, we have another great unique program, which is the State Disability Insurance System. And all workers, all private workers, pay into this system. And a portion of every paycheck goes to the SDI system. And then when we can't work due to our own non-workplace related disability or injury, we can draw down these benefits. And that extends to pregnancy or childbirth or related disabilities. You can actually receive up to a year of these benefits, but in the context of pregnancy, you would just draw them down at the same time as you're on your otherwise job-protected leave. You have to serve a 1-week waiting period, and then you can receive 55% of your wages up to a maximum of $1,067 a week as of 2013. And you can apply online at edd.ca.gov. So finally, I just wanted to show this chart, which our other panelists will be building on in their presentations, which shows on the top line wage replacement, on the bottom line job protection. And this is for a typical pregnancy and childbirth complications. And so in this kind of typical situation, the woman would go out on pregnancy disability leave 4 weeks before her due date, and then that would continue through 6 weeks post-birth for recovery. That time would all be job protected, and for that entire time, she could draw down state disability insurance benefits. With that, I will turn it over to my colleague Julia Parish, who will talk about the Family Medical Leave Act and the California Family Rights Act.
Thank you so much, Sharon. Like Sharon said, my name is Julia Parish, and I'm a project attorney here at the Legal Aid Society Employment Law Center. And we hear from tons and tons of people who have questions about exactly these issues, precisely because there are so many different laws and regulations that apply. So we're excited to be able to give you this information today, and we know there's a lot to digest. So don't worry, we have resources and ways that you can check in later coming up. But I'm going to talk about the Family and Medical Leave Act, or FMLA as we call it in the biz, and the California version of that law, the California Family Rights Act. There are certain reasons that people can take time off from work under FMLA or CFRA, and there are certain important differences between the two laws. So the FMLA is a federal law. It applies to the whole country, and CFRA is specific to California. They're similar in most ways, but different in important ways, particularly around pregnancy. And so I'm going to explain how those laws interact and how they're different for Californians. So first of all, somebody has to have a qualifying reason to take leave under either of these laws. And for both of the laws, the reasons are the same. It's your own serious health condition, which has a special legal definition, but it's not talking about something that's a temporary illness, like, you have a cold for a day. It's really a serious health condition that requires more medical intervention. The other reason is to care for a close family member that has a serious health condition. So you yourself are well, but somebody who's very close to you, your child, your parent, spouse, or in California, we also cover domestic partner who is dealing with a serious illness and needs you there to care for them. And the third reason is to bond with a new child, and this can be either a newly born child or a child that's new to your home. You're newly fostering or adopting a child, and you can take time off from work to bond with your child during that time, which is really important and for both health reasons and for forming relationships with your child. So what do you get if you have one of those qualifying reasons? What does that entitle you to? So first, it gives you 12 weeks of job-protected time off. And what we mean when we say job-protected, Sharon talked about, it's time off from work without being retaliated against. They have to bring you back to your job or under the FMLA a similar job. They can't, put you on the night shift or cut your hours or change your pay or all of a sudden give you undesirable job assignments. You really are entitled to take this leave, and you shouldn't bear negative consequences at work because you exercised your rights. The other reason that it's important to talk about job protection is because in California, in general, employment is what we call at will, meaning that an employer can fire somebody for any reason or for no reason at all, as long as it's not something that's explicitly prohibited. So, Sharon talked about discrimination. You can't fire someone because she is pregnant. That's a reason that is explicitly prohibited in the law. And this is exciting because, in general, your employer doesn't have to give you time off if you want time off under most circumstances, but they do have to give you this time off if you qualify. And they have to give you up to 12 weeks if you qualify, and that's 12 weeks per year. But there are 3 eligibility requirements, and they're really important. One is that an employee has to have worked for their employer for at least a year. They have to have worked at least 1,250 hours in the year before the leave begins, which is a little bit more than half time. And they have to work for an employer that has at least 50 employees within a 75-mile radius of their work site. And so those are the 3 eligibility requirements that somebody has to meet in order to be entitled to this 12 weeks of job-protected time off. And again, they can take it for any of those 3 reasons, their own serious health condition, a family member's serious health condition, or to bond with a new baby. One thing that's important to note about the FMLA is that it runs at the same time as job-protected time off under the Pregnancy Disability Leave Act that Sharon talked about, and I'm going to explain why. The important difference for folks in California to know is that California has a separate law, the California Family Rights Act. And even though the reasons for taking leave are the same under CFRA and FMLA and the eligibility requirements are the same, there are 2 incredibly important differences. One is that CFRA covers domestic partnerships. So if you have a registered domestic partner in California, you are protected under CFRA for your need to care or bond with that person's child or to care for them. The second is that pregnancy is not considered a serious health condition under CFRA. And this sounds like it would be really bad, right? Because that means that somebody who is pregnant is not getting any time off they're not going to be eligible for time off under CFRA because pregnancy is not a serious health condition. And remember, you have to have what the law considers a serious health condition to get time off under these laws. So CFRA has something in it that says we don't think pregnancy is a serious health condition for the purposes of CFRA. And again, that sounds like it would be a disadvantage, but it actually is a huge advantage for workers in California because what it does is provides 12 weeks of leave after somebody has recovered from their pregnancy disability and they need to bond with their child. So all of the time that they have off that is while they're disabled by pregnancy or childbirth is not going to count against their 12-week allotment of time to bond under CFRA. So they're going to be entitled to their time off under FMLA and PDL, which are running at the same time because the FMLA includes pregnancy as a serious health condition. And then once they recover, because they no longer have a pregnancy-related condition, right, which is something that's excluded under CFRA, then they get to take their 12 weeks of bonding leave after that, assuming, of course, that the worker is eligible. So a couple of other things about FMLA and CFRA is that you can take leave intermittently, which means that you don't have to take all 12 weeks of leave at once. There are some restrictions around that, but you don't need to think that you need to take all 12 weeks in one chunk. You have a continuation of your health insurance, which is incredibly important, and to keep people healthy and happy. Also, the employers are required to notify their employees about an employee's right to take FMLA and CFRA leave, and they're supposed to explain, what that means, what you're entitled to, and then also what they need back from you. So if they need you to turn in a copy of a doctor's note by a certain date, they're supposed to explain that to you and explain what will happen if you don't meet those requirements. Finally, you can be required to provide medical certification or, a copy of a birth certificate or something for the purposes of bonding. But in California, you're not required to disclose your specific medical diagnosis. California has very strong privacy protections, and so you don't need to give your employer all of your medical information. Again, this is assuming that you're taking time off because of a serious health condition, but you do need to give them enough information to know that you qualify, but that doesn't include specific medical diagnoses in California. So finally, this is the chart that Sharon was showing you, and we're going to add another piece on to explain how all of these different things are working together. So in the first part of the chart, you see at the top where the dollar signs are, right? How is somebody supporting themselves during this leave? People still get SDI benefits while they're disabled by their pregnancy or childbirth. And then below that line, you'll see that the job protection is coming from both FMLA and PDL, the Pregnancy Disability Leave Act, at the same time. And that's for the period that somebody is disabled by pregnancy or childbirth-related condition, and this is a worker who is covered by FMLA or CFRA. Remember, so they meet those 3 eligibility requirements. They're actually having 2 different laws protect them during this time. But then you see when the colors shift from red to orange, that's after somebody recovers from her pregnancy disability or her childbirth-related condition that's causing a disability. When that moment happens, that is when the 12 weeks of CFRA time to bond with her new baby kick in. And remember that this is different because in a lot of circumstances, time off under FMLA and CFRA will run at the same time. And the circumstance that doesn't happen is when somebody is pregnant. And so this is a huge source of confusion. And that's specifically because CFRA is written to exclude pregnancy, so that time off is protected by those other 2 laws. And then once she's no longer disabled by pregnancy, she's entitled to 12 weeks under CFRA to bond, and that starts after she recovers from her pregnancy. Again, a non-birthing parent is not going to have that disability time off, so they're just going to have 12 weeks total to bond with the new child. And that's a source of confusion and a big difference. But remember, if you're off because of pregnancy disability, your CFRA time shouldn't start running typically until after you've recovered. Oh, so next up, sorry, I thought we had one more, but I guess it got moved. Next up is Jenya. I'm going to pass it off to Jenya Cassidy, who is the project director at the Work and Family Coalition, to talk about paid family leave, because it's really important to have access to wage replacement during this time off for our workers. So I'm excited to hear what Jenya has to say. Thanks a lot.
Hey, thanks, Julia. Thanks for introducing me. And I'm Jenya Cassidy. I work with the Next Generation and the Children and Families Department. And we, a project of Next Generation is the California Work and Family Coalition. And we're a statewide coalition, and we work on we actually worked on the paid family leave law, passing it back in 2002. So we work on expanding some of the laws that we're talking about today, but we also do a lot of education and working on looking at how they're implemented. So that's what we do here. And I'm going to be talking about California's paid family leave law and following childbirth and adoption. So first of all, I'll just go over what the California paid family leave law is, and then I'll talk a little bit about what eligibility, length of leave, some of the details of leave, and then most importantly, how and where to apply, and then at the end, who to talk to for if you have questions about your leave, and that might be about your California paid family leave, but there may be other questions about some of the other laws we're talking about here today. The most important thing to know about paid family leave, Julia and Sharon both talked about job protection, and Sharon also talked about wage replacement. But the important thing to understand about California's paid family leave law is that it is a wage replacement law. So it's a benefit under the law it by itself right now doesn't give any job protection. And it's important that most people, when they would take it, if they work for a large enough employer, they're taking it concurrently with some of the laws that we talked about earlier. So California's paid family leave is a program that provides income replacement. And it provides income replacement to workers who pay into the SDI program and are taking leave to bond with a new child. It also covers workers who are taking time off to care for a close family member. So you can take it for either one of those issues. So when you take paid family leave for bonding, you can take it for a new child in your home within the first year of birth, adoption, or fostering. For adoption and fostering, it's up to the age of 18. So if there's a new child in your home, you can take this time paid family leave to bond with them. I had one friend who was a foster mother, and then she later adopted her foster child. So she's a rare instance where she actually got to take paid family leave twice, once when she became a foster parent and once when she became an adoptive parent, which was really important because the bonding was very, very important to the family. So for caregiving, just so you know, it's for a child, parent, spouse, or registered domestic partner. So when you pay into paid family leave, you can take it for either one of these events. So the leave benefits for paid family leave, it's out of our state disability insurance. When we passed the law in 2002, state disability insurance for workers paying into it went up a small percentage. Now, when you take paid family leave, just like when you're on disability, it's 55% of your pre-tax wages up to a weekly maximum of $1,067. And that weekly maximum, Sharon mentioned, and it's the cap and it goes up each year. This is the 2013 number. There's a waiting period of 7 calendar days. If you were a pregnant mother, I'll go over this later, you went on disability before you had your baby, you wouldn't have to wait that waiting period twice. You already did it when you first went on disability, so there would be no second waiting period. There's a cap of 6 weeks of benefits in a rolling 12-month period. And what that means is, for example, if you were going to start your paid family leave benefits tomorrow, then you have 6 weeks to take that time from tomorrow till September 14th, 2014. Many people would take the 6 weeks all together, but it's important to know that you can take it intermittently, and bonding parents do sometimes take the leave intermittently. They can take a week at a time or even a day, and sometimes for some families that works best. So another really important thing to understand about paid family leave is that this is a worker-supported benefit. When we apply for it, at that moment, we're not really applying to our employer because our employer doesn't administer the benefit. We would apply to our employer for the time off, and we would probably provide certification for that, like Sharon and Julia talked about earlier. But when we're applying for paid family leave, we're applying to the Employment Development Department. It's administered by the EDD, and we apply. You can actually apply online now. That's fairly new, but you would go to edd.ca.gov to get your application and to apply for the leave. So in process, just a couple of things to know. Provide the certification to the EDD that they will ask you for proof of the relationship, whether birth, foster, or adoption. Can apply to paid family leave up to 49 days after taking leave. They usually don't like you to apply more than 9 days before, and I'm not sure what happens if you do, if you have to reapply. Bonding, if you're taking the time off after pregnancy, it's a pretty seamless thing because you would already be on SDI, and then you would apply for paid family leave hopefully before your SDI runs out, and there's no 7-day waiting period. As I said before, some fathers can take paid family leave intermittently, and that's even on an hourly, daily, or weekly basis. A lot of bonding mothers might want to take it, especially if they've given birth, they might want to take it right after. But I've definitely known some that have taken it due to their spouse sometimes having more time off than they do. They'll delay it till a little bit later and even take 1 day a week for a while. As I said earlier, with the interaction of job-protected leave and wage replacement benefits, if you look at this chart, and at the top you have the wage replacement. At the bottom, you have the job protection. So one way I describe it sometimes is you're getting this wage replacement, and think of the job protection as sort of an invisible cloak of you can't get terminated during that time, and your job should stay the same. But for the money part, the SDI and PFL you see goes together, and this is for a worker who is covered under FMLA and CFRA. So that whole time that they're getting the wage replacement, they also have job protection. Important, for people to understand that the two are concurrent. But if we look at this chart with the interaction of the job-protected leave and wage replacement benefits, if a worker is not eligible for FMLA and CFRA, it may mean because they work for a small employer. There's a few different reasons they might not. They may be new at their job. But they still are paying into SDI and PFL. They are eligible for that. Disability leave covers more workers because you don't have to have, as was mentioned earlier, you don't have to be on the job a certain amount of time, and you can be in a much smaller employer, 5 or more employees. You're covered under pregnancy disability leave and you have a baby, you have that job protection. But at the point that you want to take paid family leave, if you see at the bottom right, it says ask employer. At that point, it's sort of between you and your employer. Some times you may have an employee handbook or something that says that you have the time off, or you may just be able to work that out with your employer. But there's no job protection that goes with just being on paid family leave. So the that I want to draw your attention to just has some really great resources for a lot of the information we're talking about today. In the Know Your Rights Guide is a really basic guide that has that information. There's other fact sheets and sample letters and forms that you might need. And then near the bottom, if you see the Work and Family Helpline, a lot of people, when they're taking leave, may have an issue. Sometimes employers will tell them they don't have the right to take the leave when they know they do. And it's really important. The Work and Family Helpline has attorneys that can answer your questions. And that's been a really great resource. So now I'm going to pass the baton to Genevieve Thomas-Colvin to talk about breastfeeding.
My name is Genevieve Colvin, and I am the Program Manager for Worksite Lactation Accommodation. I'm also a board-certified lactation consultant, and I'm just going to make sure that I can move the slide. Talk about the rights that women have to a lactation accommodation in the workplace, and also the rights of students and teachers under our laws. There are essentially 2 laws, a California and federal law, that provides lactation accommodation rights to employed mothers. In California, it applies to all employers and all employees. Some employers may be able to claim an undue hardship, but both under California law and federal law, an employer must provide a lactation accommodation until they are granted that exception, and it's a burden of proof that the employer has to provide. Employers have the right to take reasonable break time, and there is no upper age limit, so the baby can be older than a year old, and the mother still has the right to a lactation accommodation. Others may use their break times, and in California, it's a net break, meaning that the employer cannot deduct time that it takes to get to the designated rest location. It's only the time that she is actually in the designated rest location that can be counted as a break. And women have the right to as many additional unpaid breaks in order to maintain lactation. So in California, employers are required to provide 10-minute paid breaks, both in the first 4 hours and in the second 4 hours. But any time beyond the normally unscheduled rest breaks can be unpaid. The federal law has a slightly stronger provision in that it says that we must provide a place that is shielded from view and free from intrusion from coworkers and the public, and that it cannot be a bathroom. But in both cases, it needs to be very close, in close proximity to the employee's work area, and there are also penalties if the employer doesn't provide lactation accommodations when they are requested. So in essence, employed mothers have a right to break time to remove their milk, store the milk, and clean up, and that space needs to be private, clean, and in close proximity, and it cannot be a bathroom. Also, California and federal law says that employed mothers have a right to work in an environment that is free from discrimination and harassment and retaliation. So if any employed mother feels that they are experiencing discrimination or harassment or retaliation, have the right to file claims. Many are about pumps, and the federal and the California Lactation Accommodation Law does not require employers to provide pumps to their employees. However, under the Affordable Care Act and the Women's Preventative Services, breastfeeding support services and supplies are required under health care reform for the insurance companies to provide to women. This is important because when it comes to pumps and they are required to use hand expression or pumps that are lower grade, it may take their breaks, may extend their breaks and make them a little bit longer. We have others about how to request reasonable accommodations, and we encourage them to talk with their employers before they go out on birth, their pregnancy disability leave, and to talk with their doctors or their primary health care providers about their decision to breastfeed so that they have enough information before they go into the hospital so that they can make sure that they have a good continuity of care. So suggest that they talk with their employers before they return to work to remind them of their need for a lactation accommodation. And our public health recommendations are that women exclusively breastfeed for 6 months, the first 6 months, and then to continue breastfeeding for as long after as is mutually desired. And so paid family leave is very important because it has been found that when women take enough time after their babies are born to establish breastfeeding, they're more successful over time. And so we encourage women to take as much time after their pregnancies to recover and be able to breastfeed with their babies. Others wonder about space, and the minimum guidelines that the Department of Labor has provided in their request for information says that in order for the space to be functional, to be used for an employee to express breast milk, at a minimum it has to contain a place for the mother to sit, a flat surface other than the floor in which to place a pump, and ideally the space will have access to electricity so that the nursing mother can plug in an electric pump rather than use a pump with battery power. It needs to be private, not a bathroom, and also in close proximity. And some ideas about that would be private offices, a supervisor's office. It is within the law for a supervisor to vacate their office and make it available for the lactating employee. Conference rooms that they can be secured with their windows covered. Women's lounges are sometimes little spaces that are next to bathrooms, and they may be permissible if it is possible for them to be made private enough. And as long as they are not significantly within the bathroom where it might pose a health hazard to the mother and the mother's milk. Wellness rooms or sometimes closet and storages can be converted. In the picture on the screen right now is a closet that was converted into a dedicated lactation space. But we would recommend that any closet or storage be reviewed very carefully so that there is no noxious materials that are contained in there that would pose a health hazard, but there's proper ventilation and climate control in those locations. And we always encourage employers to look out for closed-circuit security cameras that sometimes pose problems for privacy. And the law doesn't require dedicated space, so temporary space is completely within the law, but we do recommend that employers with large female populations look at dedicated space as a commitment to their female employees. With teachers and students, California teachers are also covered by California law, and the California School Boards Association has a sample lactation accommodation policy, and when they recently surveyed 400 school districts, they found that only 41% have policy. So supporting teachers is an area of focus on a policy level, and we encourage any of them who have questions regarding school districts to contact us so that we can provide better support for our California teachers. In addition, under Title IX, pregnant and parenting students have the right to certain reasonable accommodations, and the Federal Department of Education Office of Civil Rights just issued guidance regarding Title IX and pregnant and parenting students, in which they specifically state that students should be provided with lactation accommodations, breaks, and appropriate space. For resources, and I would encourage you to look at the complete listing of laws at BreastfeedLA.org that outlines all of California's laws, like being able to breastfeed in public and jury duty exemption. We have policies and policy templates and policy adoption toolkits, as well as how to file claims if you feel like you're not being accommodated in the workplace. And the U.S. Department of Health and Human Services has a business case for breastfeeding that has an excellent handout to give to your employer on the return on investment for supporting employed mothers to breastfeed. And lastly, in California, we have the fantastic California Breastfeeding Coalition that has a listing of local coalitions if you are looking for somebody local to you that is working on this issue. And now I'm delighted to present Kelly Jenkins-Pultz, the Acting Regional Administrator from Region 9 of the Women's Bureau of U.S. Department of Labor.
Genevieve, it's my pleasure to share information about workplace flexibility. It's my pleasure to share information about workplace flexibility. And my remarks are going to focus on the various types of workplace flexibility, why it's an important business strategy, and how to go about negotiating a flexible workplace. Let's start by defining workplace flexibility as any program or policy that allows workers greater freedom to perform their job, regardless of the time or place, and also greater control over their work time and schedule. And on this slide, I've listed some of the most prevalent types of workplace flexibility. And as you can see, they vary greatly from limited hours of work to alternative work schedules. A recent report by the Families and Work Institute and the Society of Human Resource Management revealed that workplace flexibility is a low-cost initiative that can lead to increased employee satisfaction, lower turnover, and lower insurance costs. The United Kingdom, Australia, and New Zealand have led the way in establishing the right to request a flexible workplace for their workers. But here in the U.S., Vermont is the only state that has passed legislation that gives employees a right to ask for a flexible work arrangement without fear of retaliation. San Francisco City Supervisor David Chu recently proposed a similar ordinance that would grant San Francisco employees who are caregivers for children or dependents the right to request a change in their working arrangements in order to meet their caregiving responsibilities. And under this proposed ordinance, an employer would have a duty to consider and respond to an employee's request. The request could be for a flexible work arrangement, or they could be predictability. And a hearing is scheduled for this legislation on September 23rd. Workplace flexibility is one of the most desired workplace benefits, but it's really much more than just an employee benefit. It's a very strong business strategy, and there is significant quantitative research that links it to a more engaged and productive workforce and to reduce costs in employee turnover, real estate, and operating costs. For instance, the Family and Work Institute has found that 97% of human resource managers say that productivity is the same or better with flexible work arrangements. They also report that some companies have been able to reduce their operating costs by more than $6,500 for every person who telecommutes just 1 day a week. Flexibility also helps ease the transition of new parents back into the workforce after leave for childbirth and caregiving. But many workers aren't sure how to initiate that conversation with their supervisor. Luckily, there are many resources to help you. The first step is to do some research to see whether your company has any formal policies or programs on flexibility, and to explore how those programs have been implemented. In addition to looking closely at your company handbook or employee manual, think about others who work at the company. Does anyone telework, job share, use compressed work weeks, or seem to have flexible hours? Those people may be important resources for you, and a simple question such as, I'm really interested in learning about your work schedule and how you balance your busy work life with your family life. Do you have any advice to share about how you created that schedule? That kind of question can open up the dialogue for you. One of the issues you'll want to think about and ask others about relates to the culture at your workplace. For instance, if your firm has a strong FaceTime culture, you may find that there's some reluctance to support telework. And if that's something you're interested in pursuing, you may need to overcome some management concerns about how you'll continue to be engaged and productive outside of the office. The other important factor for you to consider is your manager's point of view. How will he or she know that you are meeting your performance standards and actually getting your job done if they can't see you, or if you're coming in late or going home earlier than other people? You'll want to think carefully about documenting your work, communicating very clearly about what you are accomplishing, and making sure that your manager knows how to reach you and is aware of the status of the projects you're working on. Technology, equipment, and resources are also another factor to explore. Some companies have bring your own devices policies, and some others want all work to be done or performed on company equipment only. And if that's the case with your company, you'll want to specify what equipment you'll need, how it will be accounted for, and how you'll take care of it. After you've thought about the culture, equipment, and technology issues, and gathered information from your company handbook or experiences of others, you'll want to do a little more research to gather some examples of the business strategy for workplace flexibility. The Women's Bureau commissioned some research on workplace flexibility in several different industries, and you can explore these on our website or print some of the materials to share with your supervisor. You'll also want to draft a written proposal that outlines the kind of alternative schedule you're seeking and addresses some of the concerns that your managers might have about it. For instance, if you're scaling back your work hours, are there some low-value work activities that you currently do that might be eliminated from your daily assignments? And what are the most important aspects of your job, and how will you continue to ensure that those are addressed? Another thing to consider is how your company's clients or how your customers might be affected by your changed schedule. Once you have the broad parameters of the alternative schedule you're seeking outlined, then request a meeting with your manager to discuss the proposal before you go on leave. This will help reassure your boss that you're planning to come back to work after your leave and that you're already thinking ahead about the transition and how you're going to be engaged and productive on the job. If workplace flexibility is not widely used in your firm, one thing that may help you is to propose a 3-month trial or pilot to test out the new arrangement and then set up a time to evaluate and adjust it after that time. After you discuss your proposal with your manager, you might need to adjust it again before it's finalized and you get a formal approval. And even if your boss gives you a simple verbal approval in a meeting, make sure you follow up with an email or a memo that outlines what you've both agreed to do. When you come back from leave, review the agreement and be prepared to proactively communicate with your boss so that there's never a question about where you are or what you're doing. Finally, keep in mind that if your coworkers don't have their own flexible work arrangements, they might be jealous and they could make some unwelcome comments about your new schedule. If that happens, the best way to respond is to simply redirect the comment back to your work with a simple question back to them. Ask, is there something you need from me, or is there something I can help you with? That way you'll get right to the issue at hand if there is a legitimate work-related concern that they have. And if not, it'll simply be a graceful way to respond to them. Now I want to give you a glimpse at some of the resources that we're going to make available to you. These and the other resources that our other panelists shared today will be sent to everyone after today's webinar. And now it's time for our questions. I'm going to move it over to Anna Fortes from the Women's Bureau to moderate our question and answer session. Anna, do we have any questions?
Hi, everyone. I just wanted to invite everyone to please use the question and answer box to the bottom right of your screen, and I will direct your question to the appropriate panelists. To start off, we have one question. This question is, if my employer provides paid vacation days, can I take my vacation during the 7 calendar day waiting period? Be directed to
yeah, you can. That's actually a really good idea to take vacation time or some other kind of paid time off during your 7-day waiting period, and a lot of people do that.
Sharon, there's also something called your benefits. your paid family leave or your SDI benefits with your other pay at work. Generally, paid family leave and SDI are designed to replace your wage loss, and so they don't want you to receive paid family leave and your full pay at the same time, but you can receive 45% pay from your employer and then 55% from the EDD for paid family leave or SDI, and that's what they call integrating benefits, which is another option for people who have accrued pay.
Thank you, Sharon. We have another question coming in. If I am unemployed, can I still apply for paid family leave?
This is Jenya. Yes, if you're unemployed, you're considered part of the workforce, that you're considered to be sort of, in the sense that you're looking for a job. So you're actively looking for a job when you're unemployed. And if you had a job prior at some point where you paid into SDI, then they would just use that as the, whatever your 55% of your income is. So the way you look at it is you're unemployed, but you're actively looking for a job. And then whether it was for bonding or for caring for another family member, you temporarily would withdraw from actively looking for a job because you're engaged in caregiving or in bonding. And then that would be the time that you would be taking paid family leave. So you wouldn't be able to get unemployment benefits at the same time that you would get paid family leave, but you can take paid family leave when you're unemployed. Does anybody want to add to that?
Okay, thanks, Jenya. We also have another one. Can you use intermittent leave before birth and after birth?
Sure, I can answer that question. This is Julia. So the answer is yes. If you need intermittent leave when you're on pregnancy disability leave, because, for example, you have a really bad morning sickness, for you need to take mornings off, that can be a form of intermittent leave, and that is allowed under pregnancy disability leave. And then also under FMLA and CFRA, for the purposes of bonding, what the regulations say is that an employer can require you to take CFRA bonding leave in 2-week increments, except for on 2 occasions you have the ability to take less than 2 weeks, meaning that, if you want to take 1 day of bonding leave 1 week and then 1 day another week, you can. But after that, your employer could require you to take your leave in 2-week increments. That doesn't mean that they have to require you to do that, and oftentimes employers are willing to work with an employee to structure their bonding leave in a way that works for both parties, because they're giving you the time anyway, right? They're required to give you the time. It's just a question of making that bonding time work for you if you need to take Wednesdays off because of childcare or that kind of thing. That's something that you're allowed to work out with your employer, but they're not necessarily required to let you do that. That's different than paid family leave. Paid family leave can be taken intermittently, and there's no kind of requirements around that. But again, as Jenya explained, paid family leave isn't something that comes from your employer or binds your employer. That comes from the state. And so the rules are a little bit different in the way that each of those work. But I would just say that if you do want to take intermittent leave, it's great to talk about it with your employer and try to work out something that works, and then you can get paid family leave on an intermittent basis during that time. And also, I just want to quickly distinguish that from taking leave for a serious health condition under FMLA or CFRA, because that 2-week requirement doesn't apply. If somebody has a medical condition that necessitates intermittent leave, then that's the way that their leave can be structured.
Thank you, Julia. Our next question is, do you recommend women buy private additional disability insurance to cover some other portion of the 45% of your income?
I can, Erin. Many employers do already have supplemental disability insurance policies. So, for example, you might get 55% of your wages from the state disability insurance program, and then maybe another 12% or even more of your income replaced through a private policy. So it's something to certainly ask your employer about. And it's really a case-by-case situation. If you have the ability to purchase an additional plan, that's possible, but some employers do provide it, or they might be provided through a union contract.
Okay, thank you, Sharon. Municipalities don't pay into SDI, PFL, and that they should buy short-term disability insurance. The other panelists have any insight on this as well. Feel free to chime in.
Just be to take that. I think the comment here is that, as Jenya and I mentioned earlier, it's really virtually all private employees who contribute to the California State Disability Insurance Program that makes you eligible for SDI and paid family leave. But many public employees do not contribute to that system. And one way you can tell if you do contribute is just to look at your pay stub. And if you see something that says CA SDI or CA DIS, then you are contributing. And if you're not, then you may be entitled to a state disability program or benefits with your public employer. And so it's a good idea to talk to someone in human resources about what options might be available to you for pay during your leave.
And just also state, a lot of the public employees who don't pay into it, there is a way to opt in, but it isn't easy because it would take a vote of your whatever is considered your bargaining unit. And definitely some public employees have done so. I've heard of libraries and some different ones, but it sort of depends on how large your bargaining unit is, and there have been votes both ways because usually people may have some other disability that they're paying into, and they all work differently. So some people will be for paying and starting to pay into SDI and some not. But I think most public employees usually don't pay into SDI.
And just one more question, and this question is, if my company offers 16 weeks of family medical leave, would they also receive 12 weeks of CFRA in a PDL situation?
Okay, I can take that. This is Julia. So what we've been talking about here are kind of the minimum legal requirements for employers to do in various situations, assuming that those employees qualify. So what the FMLA says is 12 weeks, and that's the amount that it gives. That's written in that law, and that's the floor. So employers sometimes have policies that grant more time than that. So it's possible that that individual employers give longer amounts of leave for bonding or for pregnancy disability or any of those situations. And if your employer grants you more time, that's great. Kind of what we've been describing is just what they would be required to do legally at a minimum, assuming that everybody meets all of the various requirements. The other thing that we can touch on that came up is not every employee is going to be eligible for each of these laws. Some employees don't pay into the state disability insurance program. Some employees, if you're a federal employee, aren't going to qualify for some of these state protections. And so every situation is a little bit different, and this is just kind of a general overview of the way things typically work for most folks.
So much, Julia. And a big thank you to all of our panelists today for sharing your time and your expertise with us. I think this has been a really great session, and we do have it recorded. We'll have it posted on the Legal Aid Society Employment Law Center website in a few days. We'll also be sending a copy of our resource list and our contact of all the panelists to everyone who registered today. So again, I thank you for joining us, and if you have any other questions, please feel free to get in touch with us again. Thank you.